Good morning, Isabel, Costin. I think the long-awaited holiday season is just getting started. The thing is that it will be apparently completely different than the last year, and especially different from in 2019. The COVID and the pandemic situation really mixed the cards of the employers. And this is the topic what we are willing to talk about, holiday, how we approach it as employment lawyers.
Funny that you mention it, because currently there is a case pending at the European Court of Justice concerning Austrian holiday law in context with vacation entitlements upon the end of the employment relationship. Generally speaking, as the employer, you have to pay out the outstanding days. However, there is an exemption to this rule, namely in case that the employee prematurely terminates the employment relationship without good cause, meaning without obeying the applicable notice period and termination date, then the outstanding vacation entitlements for the holiday year in which the unjustified early termination occurred forfeit. So this means in this case, the employee has no entitlement to pay out of the outstanding vacation days. And now an employee has challenged this provision of the Austrian holiday law, as he himself terminated his employment relationship prematurely and was denied the payout of 3.3 vacation days. And the employee now argues that the mentioned provision of the Austrian Vacation Act violates EU law, which foresees the fundamental right to paid annual leave, including the right to financial compensation for annual leave not taken before the end of the employment relationship. So right now, there is no final ruling of the European Court of Justice yet. However, the Advocate General has stated in his opinion to the European Court of Justice that from his perspective, the EU law precludes such a national legislation as described in Austria. So quite likely the Austrian Vacation Act has to change in the future. So I think that's good to know before starting the holiday season. How is this for you guys in Hungary or Romania?
Hungarian provisions are rather straightforward in this respect, because the first thing is that you can actually pay out holidays only in case of termination of the employment relationship. But in that case, the employer must compensate the employees for unused holidays. In addition to this, it's quite interesting. It doesn't work in the opposite direction, which means that if the employee received more holidays, so took more than is due at the time of the termination, then there is no reverse compensation duty of the employee.
Actually, that would be the same in Austria, again, except for the case where you prematurely terminate the employment relationship without good cause. So I guess in Hungary, at least, if you terminate as the employee before the notice period expires, then still you have an entitlement to get paid everything, right?
That's correct, because the Hungarian law doesn't really look at the reason of the termination, how it goes on. Even in case of a lawful immediate termination, let's so to say, whether the employer has a good cause for doing that, it doesn't really affect the entitlement for untaken holidays and for the compensation. How about you, Costin?
Well, in Romania, the legal provisions are pretty much the same as in Hungary. The annual leave is compensated only when terminating the employment. As a rule, the annual leave cannot be compensated financially. Regardless of how the employment agreement is being terminated, if the employee has an excess of accrued holiday days at the end of the contract, most likely they will receive them. And also, as in Hungary and in Austria, the other way around does not work. If the employee takes more than what he or she would be entitled to, the employee would not be required to pay the annual leaves taken in excess.
So if I understand that correctly, in all our free countries, during the upright employment relationship, no payout of vacation entitlements is possible, but upon the end of termination, it's mandatory. How is it done in your countries with the scheduling of holidays? Can the employer, for example, unilaterally schedule holidays for the employee, or do they have to have an agreement?
It's quite interesting, because in Hungary, it is the employer who schedules the holiday. So it's a right and as well as an obligation on the employer side. There is a kind of consultation duty to the employee, but still it is a unilateral decision. There is an exception of 7 days where the employee can actually use it for really private purposes. But the overwhelming part of the holiday is actually scheduled by the employer. But before we going on with the details, I think it's good to hear your thoughts about how it is going on in Austria and in Romania.
In Austria, generally speaking, an agreement between the employer and the employee is necessary. Fun fact, for 1 day of the vacation entitlement, which is 25 days per vacation year, the vacation year is the working year in Austria, not the calendar year, for one day, the employee can schedule his holiday unilaterally. It's a so-called personal holiday. For this one day, the employee must inform the employer about 3 months upfront that he wants to take this one day, and then he can do that unilaterally, but for the rest, you need an agreement.
Interesting.
In Romania, it is not specifically an obligation towards either of the two, the employer or the employee, to schedule the annual leave. The initiative must belong to the employer. The employer must schedule either collectively or individually the annual leave. It all comes down to the individual scheduling of annual leave, which again the initiative must belong to the employer. With the employee, they can agree upon a certain period of time when the annual leave can be taken. In that period of time, the employee can decide to take the annual leave with at least 60 days prior to the actual annual leave occurring, so as to allow the employer to make the necessary preparations. So I would say that after going back and forth from the employer to the employee, it comes down to the agreement between the two parties.
I'm just wondering, how long are the statutory vacation entitlements in your countries, and when do they forfeit?
Well, that's a really interesting question, because in Hungary, holidays are actually not forfeited in that sense. There's a general limitation period in employment law, which is 3 years. And in terms of holidays, the limitation period runs from the last day of the given calendar year when the holiday had to be scheduled. And the employee can still claim unscheduled holidays for 3 years. And it is also important that, for example, if the employer displays this information continuously in a payslip, that, for example, you have still some outstanding holidays which I have failed to schedule, it means that the limitation periods start again from that time. Equally, if the employee just raises a claim or just sends an email that I would like to use my unscheduled holidays from last year or whatsoever, this would also restart the limitation period, which means that in technical perspective, it never really runs out. And the other thing is that since it is the employer's duty to schedule it, immediately if the employer fails to adhere to this regulation, it continuously jeopardizing a labor inspection and potential labor fine, maintaining this unlawful situation for this thing. So we are actually always encouraging clients to either use some of the techniques or lawful measures which can be applied in order to use or to transfer holidays in after the next calendar year, or what's the best way is to schedule immediately when it's due, so in the given calendar year.
And how is it in Romania? How many days do you have, and do they forfeit? Is there a limitation period?
Yes, there is. So with the first question, the minimum number of holiday days is of 20 working days. The manner how the term when this holiday days can be taken is rather technical. So you would basically need to, as an employee, you would need to take the annual leave within a period of 18 months as of the next year, or specifically to the year coming next after the one when the right to annual leave was born. So to give you a less technical example, if we are in 2021 and we still have the annual leave accrued from 2020, you would have to take this annual leave within 18 months as of the next year. So in 1 year and a half, you must take the annual leave. As in Hungary, most employers tend to grant the employees the, let's say, oldest annual leave accrued. So you would technically not really manage to have the annual leave rights time barred or forfeited. Another reason for which the employees try to encourage by any legal means employees to take annual leave when such annual leave occurs is that upon termination, the employee will be compensated financially with the accrued days of annual leave. If you accrue a lot of annual leave days, then the financial compensation will also be rather significant. So one way to avoid this is to encourage employees to have their annual leave taken when such annual leave occurs. Otherwise, there would also be 3 years for the financial compensation of annual leave. Let's say you have terminated the employment agreement and the employee failed to pay such compensation for the accrued annual leave, and also the employee, how unlikely it may seem, did not request for such compensation. The termination date of the employment agreement would be the moment when 3 years starts to be calculated. So within those 3 years, you must, as an employee, you must act upon financial compensation and claim it.
Interesting. In Austria, as said, we have 25 days per working year, so 5 weeks. And after 25 years of employment, it becomes 6 weeks, meaning 30 days. And these vacation entitlements, there is a limitation period of 2 years after the year in which the annual leave has occurred. So overall, it's actually 3 years. And if you do not take the vacation entitlements in this time period, generally speaking, you would lose them. But I mean, in practice, employers are quite proactive about that because, as you also both stated, if the employee never takes the vacation entitlements, in the end, there will be a payout upon the end of termination, which is really expensive. But again, it can never hurt to regularly request that the employees take the vacation entitlements. And many employers also want that the employees use the vacation entitlements in the year in which they arose, because otherwise you would have to make provisions in the financial statement of the company.
There's actually a European Court of Justice decision which discussed this exact issue, the amount of compensation owed to an employee who did not take the annual leave during his employment with said employer. The European decision grounded its ruling, which was actually in favor of the employer, on the fact that the employee failed to take the annual leave when such annual leave accrued. As we all mentioned earlier, to a certain extent, the employers have, regardless of jurisdiction, the obligation to encourage employees to take their annual leave when such annual leave occurs. However, if the employees willfully avoid taking the annual leave when such annual leave occurs, so as to determine the employer upon termination of the employment agreement to pay them a large financial compensation for this, then the employees, basically what the European Court of Justice said, the employees have forfeit their right to both the annual leave and such financial compensation.
If I understand you correctly, that can only be the case if, for example, the limitation period has already expired. So if really the employee does not want to take the leave, although the employer encouraged them, then after the end of the limitation period, or if the national law has some kind of forfeiture provisions, then it would be lost.
Yes.
It's interesting what you said, because the aim of the holiday is to be really taken. And it leads toward the question, can the company really force the employee to go on holidays? In Hungary, because we discussed that it is the employer's duty to do so, yes, it is yes. And that's why it is so easy in Hungary to justify why it is the employer's duty to do so, and why the employer should pay anything upon termination if the time proportion holiday was not scheduled. And we are not really talking about forcing in Hungary, but rather scheduling. And if the employee is not willing to go holiday and he does not have any viable option or cannot really agree with the employer how to move forward and when to actually have those holidays, the employer would simply say that anyway, you should go from this period to this period. And the only thing the employer has to do is to notify the employee. So this concept of agreement is a bit far away from the Hungarian law in terms of scheduling holidays, although, as I mentioned earlier, the truth is, or how the parties are going, that they're really trying to come to an agreement. And therefore, it is interesting that you all said that somehow you have to have an agreement, which gives a relatively rather a big freedom to the employer. Say that, look, I can't force you to go on holiday, so why should I bear the consequences of your decision, dear employee, that you are not willing to go on holiday? So this is, I think, the main difference, if I understand correctly, between all regimes and the regime which applies in Austria and Romania.
Barnabás, I would agree, because in Austria, if the employee really doesn't want to go, and as said, the employer cannot unilaterally schedule it, then after the end of the limitation period, the vacation is gone. But before that, you can accrue a lot of vacation days, and upon termination, it would have to be paid out. And actually, it's paid out with the salary upon the end of termination, which is usually the highest salary. So that's really expensive.
In Romania, it's essentially the same as in Austria and in Hungary.
Given that I will go on vacation myself in a couple of days, I was wondering, well, how is it in your countries? Can the employer demand that the employee interrupts the vacation or comes even back from it? Or can the employer cancel the vacation completely before it started?
In Hungary, it's quite straightforward. The employer has the right to amend the date of the vacation previously agreed upon. As well, the employer has the right to recall the employee for vacation. And in both cases, the employer shall reimburse the costs borne on the side of the employees because of this interruption or amendment. So any damage suffered by the employee, as well as any expenses incurred in connection with this action of the employer, should be compensated. And the question is always how and when. In practice, the employees should really provide the details on the damages suffered and to provide all the list of expenses, provide a notification from the hotel, from the travel agency or whatsoever. And an interesting one, an addition, which the law also says that when you were requested to interrupt your holidays and it means that you were requested to travel back to the workplace, traveling time itself cannot be considered as vacation time. So when you receive the notification that you should stop what you are doing and please start packing and coming back to the office, it's not a vacation time. However, COVID changed things as well, not the law itself, but how we are perceiving this situation, because a lot of cases happens when the employees are requested to work during the holidays, but since they can actually manage that given task in their vacation location, we can only discuss about the interruption, but not the physical interruption of the holidays, which means that you are not requested to travel anywhere, you can stay where you are, but you are requested to work. And it is important that, okay, we can say that this is something where we can actually stop the vacation counter and would say that this couple of hours is not considered as a vacation, but working time. But in practice, there is no solution how we can actually measure and how we can pay out and what we can use it. Because if we are just saying it's like a plain differentiating between vacation time and working time, we could say that, yes, this is a working time. Maybe we can say this is extraordinary work, which is paid accordingly. And your vacation counter is stopped and this couple of hours of half a day is not considered vacation. But this is not something we can actually use in the future because we are scheduling holidays, so full calendar days. Plus, we cannot really understand the impact on the employee's holiday if we are using this kind of method to interrupt the holidays. What are the damage incurred in this case and how can we compensate it? The damage is that the employee cannot go to the beach with the family for, let's say, 4 hours. What is the damage itself? Or there would be even broader or bigger consequences because, for example, the employee paid for a particular trip during his holidays, which should be actually rescheduled, or it cannot be refunded later on. This is all something which we're just learning right now, how we are doing this. And things are making even more complicated when employees are actually started working from their different location and they are actually saying that I'm moving to the Lake Balaton, which is a pretty famous holiday area in Hungary. And some of the employees are spending their old years because of the COVID there, because they moved from the city where they are actually working to another city. And they're saying that my holiday is that I'm not going anywhere because I'm already right next to the seashore, but I'm actually just want to uncut from the grid. And if you cannot do this, how you are compensate the employee for this, because there is no real expenses occurred because the employee is actually living there. So these are the questions which are pretty interesting and new in Hungary. I would be happy to hear your thoughts about it and whether the same goes on in Austria or in Romania.
I think it's a super complex topic, and I will just give you the Austrian regulation in a nutshell, because in principle, the employer is not entitled to recall an employee from a leave already agreed upon. However, a recall is possible in certain exceptional cases on both sides, employee and employer sides, for example, from a company perspective, in case of a company emergency. If a recall is permissible, then you would have a quite similar regulation to Hungary, namely that the employer must reimburse the employee for the costs resulting from the recall. But I think in practice, it will also be difficult to see what costs are these actually. It's easier if the entire vacation is recalled and you have to stay in Austria, the whole trip is cancelled. Well, then the employer will have to compensate the employee for that. But as Barnabás, in a case how you described it, where I'm, for example, in Greece, and I booked a tour for, I don't know, seeing the island, and I cannot do it because I have to work. Well, okay, is it then this trip? Can I maybe rebook it? It's more difficult. And also, as you stated, the impact on my vacation as a whole, it's hard to put that in numbers. And I would also say in practice, although you could agree that half day is not counted as vacation, in practice, I think it's more usual that if you only work a few hours, then it wouldn't reduce the vacation that you already agreed upon. So you would consume the full day, although you worked a few hours. And I think that's the practical rule. It's certainly not necessarily what the law wants from us. I don't know, Costin, how is this in Romania?
The Romanian labor code pretty much follows what essentially both Austrian and Hungarian legal provisions set out. Let's say the conservative provision, as in your jurisdictions, says that as an exception, the employers can recall from their holiday the employees in case of force majeure or in case of emergencies which require the employee's presence at the workplace. There are no such specific definitions or exemplifying circumstances as to what the emergencies may consist of. So this is something that's pretty much left to the interpretation of the employers. If the employees are affected by this, obviously they are affected in an unpleasant way since they have to come back from vacation. But if they want to take this further and challenge this in court of law, for instance, claiming back certain costs or damages, they can base their contentions on the cause for the recall not being actually an emergency, such as stated by the labor code. As I mentioned, this is basic labor code provisions, which unfortunately is a bit left behind and not synchronized to how the present circumstances actually evolve, especially due to COVID. Due to the pandemic, most employers have adopted teleworking regime or a remote work regime. And as both of you said, employees can already work from otherwise a vacation place and choose that place of vacation in order to perform work, and in that case they would not be on vacation. However, if the employees go on vacation then they are recalled, of course the employer must pay the costs, whatever such costs may imply. Traveling, costs of not only travel tickets, but let's say meal. If you go by car for 600 kilometers, then every cost you make in order for you to get back to work will and should be covered by the employer. As both of you said, it becomes exponentially complex and more difficult to quantify the costs and the damages if an employee on vacation remotely connects to the place of work and spends a couple of hours in a certain day, and afterwards, after let's say another 3 or 4 or 5 days, again connects remotely to the workplace. That would pose some serious questions, and unfortunately, due to the novelty of the circumstances, there isn't much case law on how this should be handled by the employers.
One question that maybe we can discuss quickly. I was wondering, how is it in your countries when you terminate an employment relationship? Can the employer demand that the employee consumes the outstanding holiday entitlement during the notice period? Because in Austria, unilaterally, this is not possible. How is this in your countries?
Well, it depends whether the preconditions are met. Firstly, that there is enough time left to notify the employee on the vacation. So there is still 15 days. And in Hungary, there is a kind of split between notice period and within the notice period, there is an exemption period, which means that the employees are not obliged to work some part of their notice period, depending on how and who terminated the employment relationship. And this exemption period is something which is actually already given to the employees. So for that part, the employer cannot schedule holidays. But if there's a longer notice period and the employee is not exempted from work, indeed, if the notification can be done properly in advance, the employee can be sent to holiday even during the notice period.
And how is this in Romania?
Again, the employer cannot forcefully order the employee to take a holiday during the prior notice period, although there are many times when both employer and employee agree for the employee to take such leave. Now, about what Barnabás was saying, if I understood correctly, in Hungary during the prior notice, the employee can benefit of a certain period of that prior notice when they don't have to come to work, although they are being paid normally and without any deductions. In Romania, there is no such concept. There is no such garden leave during the prior notice, which is usually about at least 20 working days, roughly 1 calendar month. But in many cases, it's much longer. The employees and the employer can agree for them to take all accrued holiday days during such prior notice. Again, the employee cannot be forced, but this can be agreed with the employer.
Interesting. Well, guys, is there anything else about annual leave that you want to talk about that's on your agenda? Because for me, I think we covered it pretty much.
I have the same feeling, and it's a good one that we really went through all these topics.
I think we are now really prepared for going on vacation,
Definitely.
regardless of which jurisdiction applies.